So thanks, first of all, to the panelists. So thank you to Francesca Ragno, to Giuditta Cordero Mos, to Marco Torsello, and obviously also to Luca Castellani. Luca Castellani is the one who had the idea to put together two conferences. The first one we had last week, and this one is the second one. The idea is to celebrate somehow the 40th anniversary of the CISG. Last week, we had a webinar on the impact of the CISG on national law, while today the focus will be on the CISG's impact on other uniform law instruments, and we will address conflicts of law instruments, we will address the UNIDROIT principles, as well as other instruments, meaning other conventions. So the idea is that I just give a few opening remarks, basically introduce our panelists, while Luca Castellani, who is a legal officer in the UNCITRAL Secretariat, will give some remarks after Professor Marcos Torsello spoke. Of course, I will be very brief in order not to take too much of the time of the speakers. I can be brief in effect because you got all a flyer where reference is made to the bio of the panelists as well as Luca Castellani. Now, the first speaker dealing with the CISG's relationship with private international law instruments is Professor Francesca Ragno, who is an associate professor of international law at the School of Law of the University of Verona, where she teaches private international and public international law. She is also holds a PhD, of course, but you can read that. But most importantly, she also teaches on NYU's behalf as a global professor at NYU's Paris program. And in effect, she is teaching international commercial arbitration there. Then I will give the floor to Professor Giuditta Cordero Mos, who is a professor at the University of Oslo. She holds various PhDs, has been doing a lot of things. She was a judge and is now the president since 2017 of the European Bank for Reconstruction and Development Administrative Tribunal. She also represents Norway at UNCITRAL. She will talk about the CISG's relationship with the UNIDROIT principles on international commercial contracts. Now, Professor Marco Torsello will talk about the CISG's impact on other substantive law conventions, a topic he knows a lot about since he wrote a monograph on this topic several years ago. He's a full professor of comparative private law and transnational commercial law, also at the University of Verona. And he is a global professor of law at NYU's campus in Paris and has been on several occasions also a visiting professor in New York at NYU. Of course, he's also partner at Arblet, Radicati, Brozzo, Sabatini, Benedetelli, and Torsello, a boutique firm specializing in commercial arbitration and investment arbitration. Now, one thing all of them have in common, they have all links to NYU. From Luca Castellani, who graduated at NYU, among others, he holds several degrees, to Francesca and Marco, who teach in Paris, and Giuditta, who has come to NYU as well. Now, this being said, I welcome you all, and I say good evening, good morning, good afternoon, depending on where you are logging in from. This all being said, I will give the floor to Francesca Ragno.
Thank you very much. Thank you very much, Franco. Thank you for giving me the floor. Good afternoon from Italy. So it's a pleasure for me to be here and really to be part to this very interesting event. My task today will be to address the issue of the interaction, and I will use some slide if you don't mind, the relationship between the CISG and private international law instruments. However, since I have only 15 minutes available, I thought to focus on a specific issue. I will talk on the interaction between CISG and the choice of law agreement as a separate contract vis-a-vis the international sale contract in which is incorporated. So let's get started, but first I would like to specify that throughout my presentation, I will take into consideration only judicial setting, and that I will use interchangeably the terms choice of law, conflict of law, and private international law to refer to the rules of the forum dealing with the applicable law. As we all know, party autonomy is recognized in almost all domestic legal systems, in many regional instruments, and nowadays also in a very important instrument at the global level. I refer to the Hague Principle on Choice of Law in international commercial and contract. This is a very interesting instrument in my view, not only because it is the very first non-binding instrument adopted, produced by the Hague Conference on Choice of Law, but also because it aims at being a model for national, regional, supranational, or international instrument, as well as a means to interpret, supplement, and develop rules of private international law. And this is quite interesting, as we will see. Turning to our analysis, it is a fact that CFG contracts are often equipped with choice of law agreement. Such choice of law agreement, as a matter of fact, in some cases have a crucial role in determining the very same applicability of the CSG. A choice of law agreement, for example, is a factor triggering the applicability of the CSG pursuant to Article 11b. If the competent forum sits in a contracting state that has not made an Article 95 declaration, and if the private international law rules of the forum recognize party autonomy, then the selection of the law of a contracting state, for example, Italian law, leads to the applicability of the CSG. However, a choice of law agreement may be also a factor bearing the applicability of the CSG. Since Article 6 is commonly understood as allowing parties to implicitly opt out of the convention as a whole by way of the designation of the law of a non-contracting state, for example, English law, such a choice of law prevents the forum from relying on the CSG. In the light of the above, it follows that the effectiveness of the choice of law agreement may be seen often as a gateway issue for the applicability of the CSG. If the choice of law agreement is challenged or contested before a court, a scrutiny on the agreement needs to be performed. And this triggers the question of which are the legal sources to be relied upon to this aim. But first of all, which are the factors that may impair the effectiveness of a choice of law agreement? As we all know, in order to produce effects, a choice of law agreement needs, in the first place, to have been de facto agreed upon. Only once that consent as a threshold requirement has been established, it becomes possible to determine whether the agreement reached can be considered valid. As is well known, this inquiry may involve two profiles. The first one relates to the compliance of the agreement with the formal requirement possibly applicable. The second one involves the verification of the genuineness of the consent or lack thereof, covering issues such as fraud, mistake, misrepresentation, or question of capacity. Well, given that the question related to the formation and the question related to form are governed by the CSG, it seems at first that two options are available. The first one, based on the prevalence of uniform substantive law over private international law, would allow national courts to rely on the CSG rules on formation and form as directly applicable to any contractual terms of a sales contract, including choice of law agreements. The second one, on the other hand, would require national courts to rely to the conflict of laws rule of the forum as a necessary complementing tool to solve CSG-related issues. In my view, the conflict of laws approach is preferable, and this applies also to the scenario in which a court scrutinizes the choice of law agreement in the context of an Article 6 analysis. The fact that the matter of exclusion is one which is governed by the CSG does not mean that the CSG per se governs questions related to the formation or the form of a genuine choice of law agreement. The opting out of the CSG in the case considered cannot detach from the question of the existence and of the validity of the choice of law agreement. Logically, a choice of law agreement cannot perform an indicative role if it does not exist or if it's incapable to produce effects. Given that the choice of law agreement has to be distinguished from the sales contract in the light of the principle of separability, and this is because it pursues an autonomous and typical function, the function of the choice of law agreement is clearly the determination of the governing law. Well, given these elements, in my view, the question of the existence and validity of a choice of law agreement should be dealt with by relying on the conflict of laws of the forum. Only then the court can evaluate on the basis of Article 8 whether the existing and valid choice of law agreement was intended to exclude the CSG. Given the relevance of the choice of law rules of the forum, it should be noted that in the EU, courts should normally refer to the choice of law rules to be found in the Rome I regulation. I say normal because in 5 EU member states, Denmark, Finland, France, Italy, and Sweden, the 1955 Hague Convention on the law applicable to international sale of goods take precedence over the Rome I regulation. Interestingly enough, the Rome I regulation adopts a bootstrap principle and provides that the existence and material validity of the choice of law are subjected to the law that would apply if the choice of law were existent and valid. It follows that if the law putatively chosen were the law of a CSG non-contracting state, English law, for example, or Maltese law, the existence and the validity of the choice of law agreement would need to be verified on the basis of the general contractual law rules of the non-contracting states, English law or Maltese law. On the other hand, if the law putatively chosen were the law of a CSG contracting state, for example, Italian law, the issue of the existence of the agreement would be tested on the basis of the CSG rules on contract formation, as the CSG is part of the legal system chosen by the parties. On the contrary, the issue related to the material validity of the agreement would be solved according to Italian domestic law. The circular approach provided in the Rome I regulation applies also when the choice of law agreement is contained in the standard terms of one of the parties. Difficult problems, however, arise when the parties' standard terms contain conflicting choice of law clauses. A battle of the form scenario. Well, the Rome I regulation does not address this issue. There are no black letter rules in the Rome I regulation on a battle of the forms problem, of the problem of colliding choice of law agreements? Well, since the Hague Principle had been conceived as providing a sort of codification of best practices with respect to choice of law in international commercial contract, one may argue that the Hague Principle may be used as a supplementing tool to be referred to in presence of ambiguities or gaps of the relevant choice of law regime. In this case, EU choice of law regime, meaning the Rome I regulation. This is very interesting. Why? Because the Hague Principle addressed the problem in Article 6.1b. According to this rule, if the party have used standard term designating two different laws and under both of these laws the same standard prevail, the law designating the prevailing terms applies. If under these laws different standard term prevails, or if under one or both of these laws no standard term prevail, there is no choice of law. Well, having introduced the mechanism provided by the Hague Principle, it's now time to test it in relation to a hypothetical situation in which colliding choice of law agreement have been exchanged in the context of the negotiation of an international sales contract. Let's suppose that due an exclusive choice of court agreement selecting the Spanish courts, the Court of Madrid is seized in relation to an international sales dispute between a company seated in England and a company seated in Germany. Since the CIG is not directly applicable, pursuant to Article 1.1a, because of course England is not a contracting state, the court is required to verify whether the law applicable to the contract under the Rome I regulation is the law of a CSG contracting state. Let's further assume that in the case at stake, the English offeror seller issued a quotation to be classified as an offer pursuant to Article 14 of the CSG with attached standard term including a clause selecting English law. The German offeror buyer, on its part, issued a purchase order which incorporated its standard terms, including a clause selecting German law. The English seller performed his contractual obligation and delivered the goods. If the Spanish courts were to apply the Hague Principle, the analysis would require a comparison of the approach taken by German law vis-à-vis the problem of the battle of the forms and the solution provided by English law. In this respect, however, a preliminary question would need to be addressed. Is the reference to German law to be intended as comprising the CSG or as referring only to the purely domestic German contract law? In order to understand the relevance of the question, let us consider the last option first. Well, since the purely domestic German law provides for a not-out rule, whereas English law provides for the last shot rule, the case under consideration would present a true conflict situation under Article 6.1b of the Hague Principle. Since one of the designating laws applies a not-out rule, no standard term would prevail and no choice of law would be deemed to exist. Therefore, the court would be required to identify the applicable law for the purpose of Article 1.1b pursuant to the objective connecting factor provided by Article 4 of the Rome I regulation. This would lead to the designation of English law as the law of the habitual residence of the seller. As a consequence, the CSG would not be applicable. A different conclusion, a possibly different conclusion, would be drawn if the court were to apply the CSG. This is the case because according to the preferable interpretation, but the question is actually controversial, the CSG embraced the last shot rule in a similar scenario. As both as both CSG as part of German law and English law enforce the last shot rule in battle of forms cases, under Article 6.1b of the Hague Principle, the choice of law clause agreed upon would be deemed the choice of German law. And this, of course, would imply the applicability of the CSG. To sum up, we can conclude by saying that disputes on the existence or the formal validity of choice of law agreement as gateway issue to the applicability of the CSG should be dealt with by referring to the conflict of laws of the forum. This carries two implications. On the one hand, courts need to identify the relevant model choice of law rules. On the other hand, given the recognition of the bootstrap principle and given the substantive analysis required by some private international law instrument, we may conclude that at least from a private international law perspective, the relevance of the CSG depends on the CSG. Thank you so much for your attention.
Thank you very much. And let us see whether we can get back to the original screen. Perfect. So thank you very much. A few things I want to point out. In fact, in relation to what you have said, let's not forget that there are decisions out there, and I have to say a recent decision from a Dutch court, and it dealt actually with the issue of whether and what kind of agreements do fall under the CSG. And when you refer, Francesca, to choice of law agreement not being covered by the CSG and the validity should be looked at through the eyes of the conflicts of laws of the forums that will lead you to a domestic law, I would say that is, or maybe actually true. There is a decision, and the decision is one from the Court of Appeal, Arnhem-Leeuwarden, and it is a Dutch decision from the 2nd of June 2020. Why do I refer to that? Because there, the issue was whether the CSG was applicable to a retention of title clause, and the court in that decision did actually say that yes, even though property issues are not covered by the CSG as per Article 4b, the formation rules to be applied to an agreement on a retention of title clause are those of the CSG. Now, in our setting, as far as we are concerned, CSG and, for example, arbitration, something that will be touched upon later, it could mean that this specific court would apply the CSG rules to the formation of an arbitration agreement, something some of us have advocated for years, but case law has not been unanimous. So I will, of course, open the floor for questions after all of the speakers have given their talk. Thank you very much. And now I give the floor to Giuditta Cordero-Moss.
Thank you. Thank you for having invited me here, and I will try to share my screen. Let's see. Oh God, it's not there. It was there just a minute ago. Let me see.
It's always like that. You try it out, it works, you know.
It's really not there anymore. I don't know why. Can you see it now? Yes, you can see it now. Yeah, very well. Thank you very much. I've been asked to say some words about the relationship between the CISG and the UNIDROIT principles. Now, as we know, the CISG is a uniform law. It's a convention that creates a uniform law on specifically the contract of sales, while the UNIDROIT principles, they are a harmonized instrument of soft law, so it's not a binding convention. And their scope of application is wider than the CISG because it's contracts in general, commercial contracts in general, not only the contract of sale. It is often said that the CISG and the UNIDROIT principles are inspired by similar underlying principles, and therefore it has often been said that the UNIDROIT principles can be used to interpret or integrate the CISG. I have here on the screen a screenshot from the excellent database of the Pace University Law School, which has this database on the CISG, and just to show how important this idea of having the UNIDROIT principles as an instrument to interpret the CISG. I can show here that they have a guide to all the articles of the CISG, and one of the fixed recurring posts in this guide is the comparison with the UNIDROIT principles, and among other things, they have a matchup of the articles of the CISG with the articles of the UNIDROIT principles. We will come back to this one in particular, but this is one example of this very widespread opinion that the CISG and the UNIDROIT principles are sort of interchangeable. In any case, they can be used to help interpret each other. The CISG can be used to interpret the UNIDROIT principles. The UNIDROIT principles can be used to interpret the CISG. Slightly provocatively, I wrote the UNIDROIT principles, they can be used to interpret the UNIDROIT principles, slightly like Francesca just said about the CISG. I will come back to that in a minute. My question is not so much to confirm how important these two instruments are for the understanding of each other. It is rather to ask a question, is it really appropriate to consider these two instruments as equivalent from the point of view of the values and the principles they rely on? Do these two instruments really share the same fundamental values? And in order to ask or answer this question, I would like to make a case. Let's assume that there is a long-term contract for the supply of raw materials. I will take it from my own experience. Billions of years ago, I used to be a corporate lawyer in a company that produced aluminium products and aluminium bumpers for the cars. I don't know if the cars still have bumpers and if the bumpers still are in aluminium, but they were at the time. So what we needed was to procure the raw material. The alumina was one of the raw materials necessary to produce aluminium. So we had these long-term supply contracts, for example, a 5 years contract for the supply of alumina, according to which the price was fixed with a formula based on, for example, the electricity price. There was a delivery schedule, which was very, very important. Deliveries, for example, every 1st of every month for 5 years. And then there were the usual clauses like the early termination clause that we as buyer could terminate the contract prior to the term of 5 years in case there was any breach of the terms of delivery. There were these clauses about time is of the essence. So if there is a delay, then it is considered to be a fundamental breach. And in any case, we have the early termination clause. And then there was a no waiver clause that is also very common, saying that failure to perform, to exercise a remedy under the contract does not mean that, the party has waived that remedy. So this was the standard contract. Let's assume that there is a change of market conditions I, as the buyer, am no longer interested in this contract. Maybe there are still 3 years to go for this contract, and I really want to get out of this contract. So I find an old delay of 1 day, maybe 1 year ago. I never really claimed that that delay was a default, even if it was formally, because it didn't really matter at that time. However, I have a no waiver clause, which means that I have not waived my right to exercise the remedy. I have an early termination clause that gives me the right to terminate. So I use the old immaterial delay for the purpose of getting out of the contract today, because the contract is not profitable anymore. This is the scenario. And now what I would like to find out is whether the CISG and the UNIDROIT principles respond to the same values when it comes to interpreting this situation. Can I really use the old immaterial delay for the purpose of exercising the early termination right or not? Here we have 2 different approaches. On the one hand, there is the faithful application of the contract. On the other hand, there is the principle of good faith. If I rely on the language of the contract, I just see that all the formal requirements for exercising the early terminations, they are met. And it means that the formal wording of the contract gives me the possibility to terminate the contract, in spite of the fact that there is actually a speculative reason for doing that. It's not the proper reason for terminating is not the delay, it is only used for that purpose. But if you have the formal approach, you can do that because that's what's written in the contract. If you have the other approach, you cannot do that. You have to rely on considerations of good faith and of reasonableness. So this approach prevents me from terminating the contract in spite of the fact that the wording says that I can do that, because it would be a conduct against good faith. So now the question is, what does the CISG say and what do the UNIDROIT principles say in these, having to choose between these 2 approaches? What does each of the instruments say? Good faith in the CISG. There is no duty of good faith between the parties in the CISG. We know that during the negotiations of the instrument, there have been important discussions about inserting a duty of the parties to act in good faith, to interpret in good faith, and so on. But that insertion was rejected. So there is no duty to act in good faith between the parties in the CISG. There is in Article 7 a provision saying that the CISG, the convention itself, not the contract between the parties, but the convention itself has to be interpreted having regard to the need to promote the observance of good faith in international trade. So the question is whether this is a sufficient basis for permitting us to choose between the 2 approaches that I just showed you. When you have to interpret the contract, do you use the formal approach or do you use the good faith approach? Question is whether this Article 7 of the Convention is sufficient to give you guidelines in that choice. I would say that since the negotiations history of the Convention shows that the proposal to have a positive duty of good faith between the parties was rejected, then to me, this means that there is no duty to act in good faith between the parties under the CISG. Then there are the UNIDROIT principles. The picture is completely different there. There is a general principle of good faith in Article 1.7. It is a mandatory rule, which is interesting because the UNIDROIT principles, they are not mandatory. You have to choose them. It's soft law. However, if you choose them, you cannot decide to not apply Article 1.7 of the principles on the principle of good faith. Cannot be derogated by the parties. The good faith principle is mentioned explicitly in 37 provisions, last time I counted, of the UNIDROIT principles. And it is in any case underlying absolutely the whole instrument. Good faith principle is present in the negotiations, in the interpretation of contract, the performance of the contract, and the exercise of contractual remedies, so that it is an important corrective of the wording of the contract. And then it is also said that good faith in the UNIDROIT principles has to be understood not as good faith according to the legal national tradition of the judge, but as good faith in international trade, which is not really helping so much, because what is good faith in international trade is very difficult to find out. There doesn't really seem to be a general principle, a global general principle on good faith. And it doesn't really seem to be a generally acknowledged trade usage, to the extent contract practice can be considered as a symptom of trade usages. So then it doesn't seem that there is a lot of room for good faith, because contract practice is, as we know, based on the tradition of drafting that you have under English law, under the common law system, where good faith is not a general principle. So they have an exhaustive and precise regulation, and they have boilerplate clauses, such, for example, the no waiver clause that I just mentioned, that are there for the purpose of preventing external elements from coming into the disturbing the balance of the contract that has been agreed between the parties. So the purpose of writing contracts in this way is to exclude any external element, to avoid the discretion of the interpreter, and to create a bubble within which the contract is its own governing law, and the words that have been agreed to by the contract, they are sovereign and have to be interpreted literally. So it doesn't really seem that there is a lot of room for good faith in contract practice. If this can be used to interpret how good faith is in international trade, it should mean that good faith does not really have a very dominant place, which actually is quite in contradiction with the UNIDROIT principles that have this mandatory principle of good faith nominated and referred to explicitly 37 times and underlying the whole instrument. Looking at a database, the translex.org, on good faith in international trade, you can find that they consider good faith to be a general principle of international trade law. And then when they explain how to concretize, what does it actually mean? What kind of duty is it? They cite some awards that do not have really do not contribute in giving a specific standard. They cite the CISG that does not really have a duty of good faith between the parties. And they cite the UNIDROIT principles. And this is, I showed you at the beginning that the UNIDROIT principles are often considered to be a basis to interpret not only the CISG, but also the UNIDROIT principles themselves, because now here you have to interpret the good faith principle according to international trade. That's what the UNIDROIT principles tell you. And when you look in the database, how is good faith interpreted in international trade, they send you back to the UNIDROIT principles in a sort of slightly circular reasoning. So back to the match-up, as they call it, of the principle of good faith between the CISG and the UNIDROIT principles that I showed at the beginning. You have on the left side of the screen the UNIDROIT principles, on the right side the CISG. In the CISG there is this Article 7 that I mentioned. It says, in the interpretation of this convention, regard is to be had to its international character and to the need to promote uniformity in its application and the observance of good faith in international trade. That's where we find good faith in the CISG. The UNIDROIT principles, they have the corresponding article is 1.6. In the interpretation of these principles, regard is to be had to their international character, blah, blah. That's more or less the same. I understand why people say they respond to the same principles, they can be used to interpret each other. However, if you go and look a little bit further down, under the left side of the UNIDROIT principles, there is also mentioned Article 1.7, good faith and fair dealing. each party must act in accordance with good faith and fair dealing in international trade. The parties may not exclude or limit this duty. How does Article 1.7 match up with Article 7 of the CISG? I do not think it does. It is Article 1.6 of the UNIDROIT principles that corresponds to Article 7. And Article 1.7 of the UNIDROIT principles is an extremely invasive principle that may lead to not permitting the party to terminate the agreement because of an old delay, which is the case that we had at the beginning. And it doesn't really seem to be corresponding, even optically. You see that it doesn't correspond to the regulation that you have in the CISG of the same issue. So this is my last slide, the conclusion. It is uncertain that the CISG and the UNIDROIT principles share the same philosophy. This could be seen as a very marginal question, but it is not marginal at all, because whether you have to interpret the contract assuming that the parties have to interpret it in good faith or not, it makes a huge difference, because it means that you can or you cannot terminate the contract in the example that I made. So it is the adjudicator's approach to the law that is decisive. It is whether the arbitrator or the judge decides to interpret the contract literally or to integrate it with the principle of good faith. That is going to make the big difference. And the two instruments as such, they do not really seem to give coordinated, corresponding similar guidelines. So this is what I had prepared to say. I will be happy to answer to any questions or comments afterwards. Thank you.
Thank you very much, of course, Giuditta, for your words. You know that I love the law, so I love your presentation. Not only you and some other colleagues on this panel, and I have written on it. I see that some colleagues who have written on it are attending. They have different views, but today it's us who speak. Of course, I try to be funny, but let me say a few things. Let me actually point to a recent decision. When I say a recent decision, I'm referring to a Spanish Supreme Court decision from 6th of July 2020. In fact, it is relevant for today's purposes for your talk. Why? Because there actually reference is made to the UNIDROIT principles not being an instrument that can be used for the purposes of filling the CISG's gap. So this is, in my opinion, very relevant, of course. And let's also look at the substance, just a second. We know that some of the UNIDROIT principles contradict general principles of the CISG. Even some of the drafters of the UNIDROIT principles admit to that. So I wonder how one then can say, oh, you know, it's the same, you could use them or not. We do not really know whether the UNIDROIT principles always would lead to a result to which the CISG also would lead. So these are two instruments. I'm not saying they cannot be used. I'm only saying that there are certain conditions that need to be met in order for them to be able to be used as gap fillers. But this is actually something that even today we do not know. Meaning, you know, I'm sure that if we celebrate the 50th anniversary of the CISG, there will still be different views on this issue. So thank you again. And with that, I give the floor to Professor Marco Torsello, who will deal with the CISG's impact on other uniform substantive law instruments.
Thank you. Thanks to UNCITRAL and NYU Law for the invitation. Thanks to our very learned guests and moderators, Franco Ferrari and Luca Castellani. And thank you very much to all the participants for joining us today for this webinar. Unlike the other panelists, I don't have a PowerPoint presentation, but I have an old tale to recall. Indeed, the current narrative in the field of international commercial law reminds me of the Aesopian fable of the fox and the grape. A fox one day spied a beautiful bunch of ripe grapes hanging from a vine trained along the branches of a tree. The grapes seemed ready to burst with juice, and the fox's mouth watered as he gazed longingly at them. For a long time, not unlike the fox, unification agencies and prominent scholars have praised the advantages of the international unification of substantive law through conventions and the juicy benefits thereof, bridging different legal cultures, diminishing legal obstacles to the flow of international trade, leveling the playing field among parties to international contract, strengthening commercial relations among states, generating investment opportunities, and so on and so forth. Now, please don't get me wrong. I'm not trying to suggest that soft law instruments and uniform private international law instruments do not serve these goals to some extent. And of course, in no way do I intend to take a position in contrast to what has just been said by my excellent co-panelists. However, overlooking the fact that soft law instruments and uniform private law, international law instruments are somehow second best would be similar to the fox attitude, sitting down and looking at the grape in disgust, saying to itself how sour the grape must be. With respect to soft law instruments, such as the UNIDROIT principles, they have an incredible cultural and scholarly value, and they may be of importance in the development of a bottom-up international harmonized commercial law, along the lines of doctrines such as Lex Mercatoria and the like. They may also be valuable in international arbitration to some extent. However, before national courts, the conflictualist approach giving way to the law of the forum is paramount and possibly, I would say, inescapable. And international conventions, following their entry into force, become an integral part of the law of the forum. Hard law conventions thus benefit from a greater degree of effectiveness compared to soft law instruments. As far as the unification of private international law through convention is concerned, no one denies the importance of these instruments, which favor predictability and that they contribute to reduce the differences stemming from the case being brought before different domestic courts. However, uniform substantive law conventions, although they cannot entirely exclude the need to resort to private international law, avoid the two-step approach of private international law leading to different domestic laws, thus allowing the reduction of learning costs and ultimately the reduction of transaction costs. These are areas of international commercial law where the position that I just took would hardly be put into question. In areas such as IP law and transport law, this is evident. In the area of IP law, the unification effort dates back to the Paris Convention of 1883 on the protection of industrial property and the Berne Convention of 1886 on the protection of works of art. In this case, the driver of unification was the need to provide effective cross-border protection of IP rights. Effectiveness might be regarded as the key in this respect. In the area of transport law, unification efforts date back to the Berne Convention on carriage of goods by rail, concluded in 1890. The driver of unification in this case was clearly the reduction of transaction costs, as unloading and reloading merchandise at every national frontier would have been an unbearable burden at a time of rapidly growing cross-border trade. Now, unification efforts in the area of sales law have proceeded along the same lines of other efforts toward international unification of substantive law in areas such as the one that I've just mentioned, providing an effective legal tool, reducing transaction costs for the parties, but also bridging legal cultures, favoring international trade, and so on and so forth. The CISG constitutes the culmination, the apex of the efforts put in the unification of sales law, building on the experience of previous convention, including the 1964 Hague Convention on the international sale of goods and the formation of contracts in the international sale of goods. The CISG has deployed a unification strategy, which has then become the template for subsequent conventions. Many of the salient features of the CSG have become common features of uniform commercial law conventions. Here I would like to recall three of these features, which I consider to be of particular relevance. First one, the limited sphere of application of the convention. This serves the goal of to overcome states' reluctance by allowing the preservation of domestic law for domestic sales, and in the absence of a significant link with the transaction. Internationality in this respect, it's a key factor. The CSG applies only to international contracts so as not to affect domestic sales law with respect to domestic sales. Internationality under the CSG, as well known, is based on a very simple subjective test based on the location of the places of business of the parties in different states. However, internationality is not sufficient for the CSGs to apply. The additional requirement for the convention to apply consists of a link between the transaction and at least one contracting state. This could be a geographical link, both parties being based in contracting states, or a legal link, the rules of private international law of the forum leading to the application of the law of a contracting state. The second salient feature that I would like to mention is the dispositive nature of the CISG. This feature serves the goal of overcoming criticism based on the benefit of regulatory competition, in that parties are free to choose a different competing legal regime other than the CSG if they want to do so. Under Article 6, parties may opt out of the convention as a whole, or they may derogate any of its provisions. There are exceptions to this general rule, but they are limited. Article 28 is due to the jurisdictional aspect of the enforcement of specific performance. Articles 11 and 12 have a different justification. Article 11 creates a protected area against domestic rules on validity based on requirements as to form. And Article 12, in combination with Article 96, provides for a reservation, so by definition, a limited exception, available to states that regard requirements as to form as a matter of quasi-public policy. I'm not entering further into that notion here. The third feature that I want to mention, rules on the interpretation and gap filling of a non-exhaustive international instruments. This is very important, as the pursuance of the goal of unification requires not only the creation of uniform rules, but also the uniform interpretation of those rules by the decentralized domestic courts called upon to adjudicate. And it also requires coordination of the non-exhaustive treaty text with possible other sources. As far as the interpretation of the convention is concerned, we all know that Article 7 requires regard to be given to the international character of the convention, the need to promote uniformity, and its application and the observance of good faith in international trade, as has just been recalled. Article 7.2 deals with gap filling. It promotes an autonomous gap filling method, minimizing the need to apply rules of private international law and possibly excluding resort to soft law instruments such as the UNIDROIT principles. Now, let's look at how this salient features have been received in subsequent convention. All these features, as well as others, as a matter of fact, have been reproduced also in subsequent conventions, although at times with some relevant, slight but relevant deviation, which are worth reviewing. First one, the limited sphere of application, the feature of internationality, which has been taken over consistently by subsequent convention. The Leasing Convention adopted it in its original subjecting fashion and referred to the places of business of the lessor and the leasee. Other conventions, such as the Agency Convention in 83, the Factoring Convention 88, the Independent Guarantees Convention, adopted an objective criterion due to the functional link between the transaction that they're meant to govern and the CSG, the sales transaction. And a closer scrutiny reveals that, for instance, the objective internationality of the assigned receivables stems from underlying subjectively international sales contracts. Now, there are drawbacks of this two-tier approach. Two identical transactions, or even two parts of the same bulk transaction in the event of assignment and factoring, may be governed by different sources. The assignment convention tried to overcome this, but created an overlap between internationality and applicability. As a result, the convention applies to international assignment of international receivables, to domestic assignment of international receivables, and to international assignment of domestic receivables. The solution has generated concerns which have not helped, probably, promoting the convention, which is still not in force. Also, the applicability requirement of the CSG has been largely reproduced in subsequent convention, which have adopted the solution based on the combination of a geographical and a legal link. A surprising exception in this respect is the 2005 Electronic Communication Convention. The surprise actually well hidden into the chocolate egg of the Secretariat's explanatory note, which states at page 13, and I quote, as regards the fair application of the convention, that the convention applies when the law of a contracting state is the law applicable to the dealings between the parties, which is to be determined by the rules of private international law of the foreign state, if the parties have not validly chosen the applicable law. Regretfully, this is not what Article 1 of the convention states. Article 1 states, again I quote, this convention applies in connection with the formation of, or performance of a contract between parties whose places of business are in different states, period. This seems to me to trigger the application of the convention as law of the forum, irrespective of the law applicable to the transaction by virtue of the rules of private international law of the forum. The solution is even more puzzling in light of Article 19, which provides for the possibility for contracting states to cause the convention to apply, again I quote, only A, when the states of the parties' places of business are contracting states through this convention, or B, when the parties have agreed that it applies. Now, option A obviously corresponds to Article 11A CISG. Option B conflicts with the prevailing approach that excludes the applicability of international conventions by virtue of a mere opting in. The second salient features and the impact on subsequent convention, this positive nature of the convention. Substantive uniform commercial law conventions have followed the CSG solution, which allows for the opting out by agreement. They've also often followed the approach introducing protecting area, Article 11 model, where domestic rules on validity do not apply. This is the case, for instance, as regards Article 5 of the Factoring Convention with respect to bulk assignment of future receivables. It is also the case with respect to Article 8 of the Electronic Communication Convention, which prevents denial of validity or enforcement of a communication on the sole grounds of its being electronic. In limited cases, drafters have also introduced mandatory rules. Article 8, the Leasing Convention, is a good example, but often they have coupled these rules with a reservation, with the possibility for states to declare a reservation. The exclusion as a rule of mandatory rules from the scope of international convention may be problematic as regards complex transactions or transactions where third parties or weak parties are involved. This problem, however, is not exclusive to legislative-based uniform instruments and reflects the role that national laws retain whenever sensitive issues are at stake in international business. The last feature that I mentioned with respect to the CSG, rules on interpretation and gap filling of a non-exclusive international instrument. The CSG rules on interpretation and gap filling have been adopted with very minor changes by all subsequent conventions. Only the requirement of observance of good faith has been abandoned in some cases. This approach acknowledges the adversity for homeward interpretation and the need to contextualize the convention's interpretation in the scene of transnational commercial law. The acknowledgement that a coherent legal framework has been developed by transplanting CSG's features into subsequent conventions justifies the claim in favor of an interconventional interpretation. One example may be the notion of place of business, not defined in Article 6 of the Electronic Communication Convention, although Article 10 refers to the non-existent definition of Article 6, which may and must be interpreted in light of case law developed under the CSG as regards the notion of place of business. Another example may apply to the interpretation of fundamental breach under Article 25 CSG and the interpretation of default under Article 11 of the Cape Town Convention, as a coherent interpretation would be critical in the event of concurrent application of these two instruments, in the event of a sale of goods governed by the CSG containing a retention of title clause governed by the Cape Town Convention. So let me get to the conclusion of this short presentation by stating that the CSG is undoubtedly a successful piece of uniform substantive law in terms of number of contracting states. It has been, and it still is, essential to establish uniform law in this area, as sales are the basic contracts of international trading goods. The CSG unification strategy has been taken over by subsequent conventions, which, although in most cases not as successful as the CSG, have contributed to the creation of a coherent legal framework where cross-references and interconventional interpretation are possible. From the past experience in the development of uniform substantive law conventions, from the analysis of the way in which the CSG unification strategy has been applied in different contexts, and from the review of deviation from that model, we can now gather important information which might guide possible future efforts toward legislative unification of international commercial law. The limited success of some of the conventions that follow the CSG may be attributed to different factors which made them unattractive to states. In some cases, this may be attributed to the convention's nature as a merely ancillary piece of legislation complementing the CSG in areas where national legal doctrines differ greatly, agency, or where interests of third parties are involved. In some other cases, the limited success may be attributed to the fact that the convention has a highly sector-specific scope, but didn't gain the support of the stakeholders in that specific sector. An exception in this respect applies to the Cape Town Convention. This situation has led to a...
I have to ask you to come to your conclusion.
Sure. This situation has led to a decade without convention, although it has been an extremely active decade. In the meantime, the economic shift from a trading goods-based society to what is often referred as the age of access has also led to an increased relevance of types of contracts other than the sale of goods, namely service contracts, including online acts as a service type of contracts. We could struggle with the legal toolkit that we already have, arguing that qualities such as accessibility, compatibility, portability, interoperability, and the like are nothing but facets of the fitness for good governed by Article 35 CISG. Or otherwise, we could take up the challenge and consider the possibility to give impulse to a virtuous process aiming towards international unification through convention of the discipline of the basic contract for the digital age, that is, the service contract. The moral of the tale might be in this respect, hey folks, that grave you're staring at is still very good after 40 years, but some new juicy fruits might be blossoming on the tree of international commercial law. Thank you very much.
Thank you very much for your talk. Yes, you actually touched upon a very interesting issue, meaning that in one of those cases, the report accompanying the convention says something completely different from the text. I'm referring to the Electronic Commerce Convention that basically accompanies also the CSG and of course has a broader scope. And that's something that has been noted and it is interesting to note. So thank you very much. And with this, I give the floor to Luca Castellani and ask him to conclude at 2:30.
Thank you very much, Franco. Thanks to you, to NYU for hosting this very interesting webinar. I'm very happy that this will be made accessible also to those who cannot participate now. Many thanks to Francesca and of course to Giuditta and to Marco for what they said. I will try to say only two things so that maybe we still have a few minutes to reward our audience, because we know the audience is the most important part of the event actually. First thing, I have of course listened very carefully to all the interventions, but especially what Giuditta said is exactly what was discussed in the very recent legal guide to uniform instruments in the area of international commercial contracts with a focus on sales. And I have to say, this legal guide in almost final form is available in 6 languages on the ANSWER website, on the Commission webpage. We are of course consolidating and we will issue it as a publication. But in particular, the relationship between CSG and UNIDROIT principles, we all share immense respect and affection for UNIDROIT and for the work that was done for the principles. There are cases where the two texts do not seem to be exactly on the same page. We have heard that a lot very recently with the discussion of hardship, force majeure, and the possibility to excuse non-performance in the COVID-19, for instance. So this was the marketing part. There is I would like to invoke a no waiver clause. Marco and you made me immensely happy by starting a discussion on the scope of application of the Electronic Communications Convention. And we will have a separate webinar with the 3 of us and maybe one interested person in the audience to discuss this extensively, but that's another time. For the time being, I want to say I'm not passing on to that one. The conclusions that I would like to say now, they pertain on the bigger picture. Point number 1, uniform law does not need to be and will never be the only source of commercial law in the world. It is a really important model that interacts and influences the development of domestic law, in some countries more, in some countries less. So what is important now is to be aware of that interaction that is also intellectual. What is maybe different in uniform law is that uniform law does embrace, in my opinion, as a core value, freedom of contract. And freedom of contract as an enabler of economic development. So to the extent that we promote uniform law, and when people who will read the guide on the uniform commercial contracts will see that what really counts is that the parties understand what we are doing, understand what we are choosing, what we are opting in, and find the best solution for their needs, no matter if it is a uniform text or not. And so, especially the Hague principles, but also the CSG, they all lead in that direction to support freedom of One element, a final element that I want to mention, and that is my really important takeaway, UNCITRAL actually has also a mandate of coordinating efforts. But of course, UNCITRAL is small and the efforts are many. Where actually, there's quite a bit of resources in this field, of course, not a lot of resources compared to our fields of international law, but still there are many efforts, especially at the regional level. It's extremely important to coordinate efforts and ensure consistency. But of course, what is more important is to promote participation in the text, understanding of the text, use of the text. I believe that all of you will find the legal guide provides a really important contribution to that. Of course, we are here to do our best, and we thank you for all the important intellectual input that you give in this collective effort.
Thank you, Luca. Thank you very much. And again, as I mentioned before, this initiative goes back to Luca Castellani specifically, and we're happy to join UNCITRAL in these efforts. Allow me to also mention that tomorrow there will be another effort. It is done together with some colleagues from Brazil, specifically Rafael Alves initiated. Tomorrow there will be a conference, a webinar, of course, specifically on the applicable law to the merits in international arbitration and the role of the CEED in relation to hardship, force majeure, frustration, where some of these issues actually may well be touched upon again more in depth as far as the substantive solution is concerned. We will have a talk on how the Sales Convention can apply, for example, in arbitration, a talk on law applicable in general by Professor Judita Cordero Moss, and some specific talks relating to the substantive issues and differences. And here again, I would like to point out some differences between the CISG, for example, and the UNIDROIT solution. And again, we do not know yet what the final solution will be, because courts have applied the CSG differently. They have looked at the relationship between one UNIDROIT principles and the other CSG in different ways that has led to different outcomes. Now, one of the questions was whether this webinar will be available. Yes, you should look out for it. We have specifically recorded this webinar. So this is something that I want to point out. Thank you to everybody, of course, for their contribution. Thank you for making yourself available. Thanks to the audience. And I have to say the audience comes from all over. We have emails from, or chats from people from India, to participants who actually come from other areas. We have here somebody from Brazil, somebody who was actually a student of yours, Judita, and who thanked you for your great classes, somebody from Guatemala and so forth. So thank you to everybody. Thanks to the speakers. Thanks to Luca for pushing this. And I hope to see you soon. Thank you to everybody.